issue in the matter of Kerish International Motors and Opel Automobile.
Yes, Mr. Sinclair.
Yes, my lords, I appear on behalf of the appellant, whom I shall refer to as Kima. Mr. Andrew George and Ms. Drishti Suri appear for Opel. My lords, I think we have to deal with the issue of adjournment first.
Yes, well, it's a question of where do we go from here?
Yes, exactly. So, my lords, the starting point is that the parties have agreed that in accordance with the court's provisional view, they should jointly write to His Majesty's government, posing the two questions proposed by the court and asking if the government wishes to intervene.
Yeah, we, as you can imagine, we have discussed this between ourselves.
Yes.
And indeed, before we formulated the questions, we had a discussion about it. Our current thinking is that in order to provide HMG with context, HMG should be supplied with the judgment below,
Yes.
the appellant's notice, and the skeleton arguments as part of the pack, as it were.
Yes.
Sorry? And Lord Justice Miles's
Yes,
order.
Yes. My lord, we respectfully agree with that. I think we would also suggest the two expert reports from the Dr. Katan and, about the Palestinian issue, just so that
well, at the moment, we're not convinced that they bear on the question because of what was said in the Deutsche Bank case,
Yes.
which is that in domestic law, there's no room for implied recognition.
Yes.
But that there may be, it may be, depending on what HMG says in response to the questions, there may be some room.
Yes.
But since the experts disagree with each other,
Yes.
we think that they must meet and see if they can narrow the issues, if not agree a joint statement. But that may itself be something which should await the response of HMG.
Yes. Okay. And so does your lordships think we should not send the expert report?
That's our current view.
Okay. Well, I'm not going to seek to persuade you otherwise. My lord, then the question is what we should do now. There appear to be three options. First option, which is the one we suggest, is that we adjourn the current appeal until we have heard back from His Majesty's government, and then relist the appeal. At that stage, I've had a brief chat with my learned friend. He doesn't agree with this, but he says if we do that, and I agree that maybe we should extend the time estimate to 2 days in that scenario. The advantage of that approach is it's clean. All issues can be resolved together at a single hearing. All issues in the current appeal and anything arising or not arising from whatever the government says can all be dealt with together at the next hearing. The government is given a reasonable opportunity to respond and its response to be taken into account by the parties and the court. And this gives the parties a reasonable opportunity to consider that response and how they wish to deal with it as well. So those are the advantages. It also means that if His Majesty's government wished to intervene, then they could do so in terms of turning up at a hearing. The disadvantage, obviously, is delay, although all the options involve delay. And the other disadvantage is cost, which we tried to mitigate by seeking agreement to adjourn today, but obviously not without success. So anyway, my lords, that's the first option. The second option, which my learned friend suggests, is that we go ahead now and argue the appeal in full, and that the government responds before if the government responds before judgment is handed down, then the parties can submit brief written submissions. And I don't know whether your lordships have seen the letter that was sent by TKD yesterday setting out that proposal. Sorry, by Shoesmith yesterday setting out that proposal. The problem with that, my lords, is it doesn't deal with the question of what happens if the government has not responded by the time judgment is to be handed down. Surely the Court of Appeal cannot give a judgment on the issue in which they've been asked to intervene, if they want to, without having heard what they want to say about it. And it would be seriously problematic if this court gave a judgment which was contradicted by what His Majesty's government later indicated was their position. So it can't work, in my submission, that your lordships can just hand down judgment before they've heard back from the government one way or another. But equally, it doesn't seem sensible for the appeal to be fully argued, but the court to await delivering its judgment until we've heard back from the government, because we don't know how long that will take. Your lordships, is it the suggestion that they would write their judgment immediately, but then sit on it, or wait and then write it later in who knows what length of time later? And also, what if the response from His Majesty's government involves more or requires more than brief written submissions? What if it involves oral submissions, for example? That would be very difficult to manoeuvre the same team together on another day. And what if His Majesty's government wishes to intervene, and therefore in a proper way, in the sense of attending the hearing and making submissions, having heard our submissions? That is not practical if we followed the suggestion of my learned friend. And really nothing much is achieved by that, because there will still be a delay as well.
On the basis proposed by Mr. George's team,
Yes.
I assume that we would hear the appeal on the assumption that we are free to apply, I'll put it in inverted commas, Palestinian law.
No, I don't think so. I think he would still be arguing that point with your
Yes,
lordship.
but on the basis that Palestinian law is the governing law.
No, I don't think so. As I read their letter, Shoesmith's letter, their position is, paragraph 6, they say, we consider the parties should present their cases in relation to the national law issue in the normal way at tomorrow's hearing, and by which they mean this whole argument about what the meaning of national law is.
Yes, I think
whether it can.
I think that's what I was suggesting.
Oh, I see. I'm sorry, but
we assume that HMG have no objection to the application of Law 2 of 2000.
I think that. Well, I'll wait.
Well,
to hear
as
what
I
Mr.
understand
George
it, the
says.
first argument is it's actually not Palestinian law that applies under
That is
the
the first,
meaning of national
yes.
law anyway. So the
Yes.
issue is, what does national law mean?
Yes.
I think what my lord is saying is that if it does in fact mean, sorry, if as a matter of interpretation it
Yes.
doesn't mean English law or it means
Palestinian.
Palestinian law, then the argument, as it were, assumes that it could be applied in those
No,
circumstances.
I will hear from Mr. George, but as I understand it, he would like to argue that point as well, that even if it does mean Palestinian law, nevertheless, for public policy reasons, the court should not apply Palestinian law. I believe that's that they anticipate all arguments that they make and that we make in our respective skeletons will be made today. There will be no further argument from us.
Yes.
And so we will fully argue that.
Can
issue.
this court decide questions of public policy without knowing what HMG says about it?
Well, it's a matter. I think.
Would it be of assistance,
Yes.
my lord, if I
Yeah.
set out, as my learned friend says, there are three options. We adjourn now.
Yeah.
His third option, which will be my primary position, and he will doubtless come to, is we just deal with ground one of the appeal and do nothing with the national law point, and I'll make
I see.
brief submissions on that. My third position, if we argue the appeal in full, would be to argue what we have currently set out in our skeleton argument. My lord is quite right. That is that it does not mean Palestinian law for various reasons, including the fact that Palestine is not a national state. But we have not taken public policy points for the reasons that my lord has outlined in the absence of the government setting out its position. And I would not intend to argue those points from nowhere if you are minded to proceed to hear ground two today. You're right, of course, my lord, that does leave the possibility that despite not having argued it, the government do respond to the invitation and say, yes, there are public policy points here, and I accept that requires further submissions. I accept that as a scenario in which further submissions would be required, but I certainly wouldn't be addressing the point if we proceeded to hear part of ground two today.
Yeah.
That's very helpful. So I think that is a change from Shoesmith's letter, but maybe I misread it. So he's gone for option 3, I think, which was which was the suggestion that we argue the substantive Palestinian law question today, and indeed we could also address the contractual interpretation question, whether national law means Palestinian law, but that probably overlaps with the status of Palestine as a country, so it'd probably be better not to argue that. So we would just be arguing the substantive question, which is assuming it means Palestinian law and there are no public policy issues, what is the answer as a matter of Palestinian law? And did the judge get it wrong?
Right. Where does that leave the experts on international law?
Well, if we went on that basis, we wouldn't need those experts. That's true. So we would just have the appeal dealing with with those issues on substantive Palestinian law. But the problem with that is that Lord Justice Mayors has considered that we have a real prospect of success on the Palestinian law question. So we may win on that issue. Obviously, if we lose on that question, then I suppose that's a great result for justice, not for us, but for efficiency, because then we wouldn't have to come back. But if we win on that issue, then that's a real problem, because then we do have to have a phase 2, at which point it's necessary to reconvene this panel and the council teams at some unknown future date, once we've heard back from His Majesty's government and once it's been relisted. Everyone's memories will have faded, maybe. I don't know how easy it will be to rearrange that, and we'll have to re-argue the case to some extent, as well as dealing with the new point, and we'll end up with 2 hearings, the overall greater length, cost, time, expense, and worse justice, I would suggest. So, and really, given that I assume your lordships are not going to form a preliminary view now as to whether I'm going to win on the substantive Palestinian law issue, then it must be right that there's a real risk that I'll win it. In which case, Mr. George's suggestion is very unsatisfactory. So we are of the view that your lordship should adopt the first option. Another point on the third option is that there is a slight discourtesy as well to His Majesty's government, although I suppose we could do it in a different order. But if we were to write to them this week and say, please, do you want to intervene in this appeal? What's your view on various questions? And then we hear the appeal. Whenever your lordships hand down judgment, you decide it. And then we write, and if it's against me, we write back to the government and say, oh, actually, we've changed it. Ignore that. You don't need to get back to us. So, I suppose we could wait until your lordships have handed down the judgment to ask His Majesty's government whether they wish to intervene, but that just builds further delay. So the only clean approach, my lords, is option 1. Seems perfectly sensible. The only downside, as I say, is the delay. But there's a real risk of delay with all of the options.
Right. What about the experts on Palestinian law and the new materials that are relied on? What's the position there? Are the experts going to have to be cross-examined?
Well, no one has suggested that.
Well, if the experts disagree, how does this court decide between them without hearing them?
Well, there is law on that, my lord, isn't there? It happens. And obviously, it makes it more difficult for me to persuade your lordships, but I will be seeking to persuade you that you, by looking at the written materials and the judgment, you can form your own view that the judge got it wrong to the sufficient standard, which we'll have to discuss what that standard is. So that's right. But, another side advantage, I guess, of adjourning today is that, as your lordships know, they have relied on 2 new first instance decisions in Palestine. Both of those decisions, the appeals have been heard, and the Court of Appeals are ready with their judgments, in fact. But it has been delayed due to various events on the ground. But they are due, at least one of them, I think, and maybe both are due to be handed down in September. So at least by September, we would also have insight into what the Court of Appeal says about in Palestine about those two decisions of Judge Askelan. So that's the side advantage, although I have to say our primary position is that your lordship should exclude that evidence anyway. But that's a matter to be argued in due course. My lords, unless I can assist further, those are my submissions on that.
Thank you. Yes, Mr. George.
My lords, we agree that there are three options before this court as to the way forward, and it also appears to be common ground that ground one, the substantive Palestinian law issues, or whether the judge erred in principle in his application of Palestinian law to the facts, is an entirely freestanding ground, which does not raise any of the concerns or considerations about national law or geopolitics which arise in relation to the second issue. Now, my learned friend is obviously right. There are issues of court constitution and court practicalities which I cannot assist you with and you will know. But subject to that, in our respectful submission, the most consistent course with the overriding objective, when you have a court which has read into the case, legal teams which are ready to argue it and costs that have already been incurred, is to hear the argument on that one issue, informing His Majesty's government of the course which the court has adopted and the contingent circumstances in which the second issue may arise. And in making that submission, I am not in any way presupposing that we will win or that you have any views as to the merits of the result. But of course, in most cases, it normally arises at first instance, where some form of bifurcation or preliminary issue is proposed and canvassed. It is normally on the basis that it will be dispositive of the case one way, even though it won't be dispositive of the case the other way. And in many situations, the practical course, the course most consistent with the overriding objective, is to hear that issue that can be fairly heard and determined on the day, recognising that there are circumstances which may mean it's not positive of the whole appeal.
Does it raise any jurisdictional question? If we were to address the case on the basis that the court assumes it can treat something as Palestinian law in circumstances in which, in the light of HMG's subsequent views, it might take the view that there is no such thing as Palestinian law that this court can apply, does it have jurisdiction to address an appeal on that basis?
My Lord, in my submission, that issue would not arise in circumstances where, regardless of whether Palestinian law can properly be characterised as a national law for these purposes, there is no doubt that the expert evidence before the judge proceeded on the basis that there is a body of jurisprudence which can be analysed in accordance with how a Palestinian court would be analysed and a result determined. Regardless of whether that is or is not something which you would recognise as law for purposes of public policy or for purposes of the phrase national law, the parties have proceeded, common ground, that it exists in the sense that it can be analysed and has been analysed by the experts. We are, of course, in a position where, rightly or wrongly, that has happened. It happened below, and yes, we have a result.
If it's a jurisdictional question, it doesn't matter what the parties agree.
I accept that, my lord, but the jurisdictional question in my submission arises as to whether, and my lord's question, the Court of Appeal's question, gives effect to this. It was contrary to public policy for Palestinian law to give effect to Palestinian laws applied by courts in Palestine. Now, the claim for relief in these proceedings was indeed for a claim, a declaration, as to what Palestine law is. And I can see that could give rise to that jurisdictional issue. But there is no counterclaim for a declaration as to what it isn't, if I can put it that way. I simply asked for the claim to be dismissed, and indeed that's what occurred below. So if you decide that the appeal fails on this ground, this court will not be giving effect to Palestinian laws. All this court will be deciding is that no relief should be granted by this court, declaratory or otherwise.
It would be treating there as being something which constitutes Palestinian law in the eyes of this court, which, if it's speaking with one voice with the executive and the executive takes a different view, might arguably be said to be something which it has no jurisdiction to do.
And you could test it this way: what declaration would the court be having to make at the end of the argument, consequent upon its judgment?
Well, my lord, that in a sense is exactly the point which I rely on. It would simply be saying the appeal is dismissed.
Well, that assumes you win.
If it,
What if the appellant wins? Then what?
on this hypothesis, the bifurcation procedure I am putting forward, then we have to go on. Because this court has decided His Majesty's government must be, and we all agree, must be informed of the issues, must be invited whether to intervene. The question being put forward is simply, should we determine issue 1, at which point one can then say to His Majesty's government, either there is now a second issue in which you must intervene, because this court would be minded to give effect to Palestinian law, subject to the questions which must now be determined.
But the problem is, I mean, as you say, if you win, the order could simply be appeal dismissed. But if you lose, how would the court record the consequence of the ruling which it would have made? It would have to say what?
In my submission, that is not. I appreciate in an ordinary case one might do that because it would be useful to set out what you are saying the Palestinian law is.
The court would declare that Palestinian law is X.
But nobody, in a sense, if one looks at it strictly, nobody is asking for this court to make any such declaration.
Well,
on this basis, if we dealt with this issue first, the court would simply direct that there be a further hearing or written submission, or however the court wanted to deal with it, to deal with the remainder of the issues, which we all agree can be defined as the national law issue broadly on this basis. So the court would not need to do that. There would be the relief would only be whether the appeal is to be allowed at the end of both hearings. It's really, in my respectful position, my lord, it's a practical question, I accept that, and there are clearly points to be made both ways. But what I'm suggesting is really nothing more complicated than a preliminary issue, as one might have it in a normal action, where one takes the first issue, which doesn't raise the third-party problem. We can get on with it without His Majesty's government. And having dealt with that, and if necessary, we invite His Majesty's government to consider the second issue. And in my submission, whilst I entirely hear my lord's point, it is perfectly possible for the court not to declare the matters they have currently found before hearing that second issue. And in my respectful position, that should not be the issue that determines how we proceed today. There are obviously other issues, as I say, including court constitution and practicalities that may militate against what I put forward. But in our respectful submission, that has the advantage of we use the time today. There are a number of issues that come up. I mean, my lord has already, even if we hear the substantive law issues, there's an interesting issue about the new Palestinian judgments and what we do about those. I agree with my learned friend. Nobody is suggesting the experts should be cross-examined further. I mean, it's not, we have, I think I speak for both of us, we have tried to be helpful. There seems to be a dearth of authority. It hasn't come up, as far as we can see, this issue if you have a finding on a foreign law and then new foreign law decisions by the time of the appeal. And there is obviously a threshold question about whether, except my learned friends, whether it's even relevant. Are you simply looking at what the judge had before him? Did he err in principle? And if it is relevant, well, what does the appeal court do with these new judgments?
As I understand it, both sides are asking us to take into account that fresh evidence, in one case on a contingent.
Precisely.
Exactly. Contingent basis.
Yes.
But assuming that the court has to decide whether to admit it, that will involve applying the merits element of the Ladder-Marshall test,
Precisely.
which in reality means hearing the evidence, hearing loosely. Now, as I understand it, your case is, when you're dealing with the substantive Palestinian law issues, that on the spectrum that Perry and Lopag says one must apply, this is right up at the end of findings of fact, because this is not foreign law with which the court is familiar. It's based on translations. It's based on disputed translations, even of the law instrument itself, and therefore it was for the judge to assess what the experts said about it.
Precisely.
Well, why doesn't that equally apply to the new material that the parties will have to put before us, de bene esse at least, and on which we will have to form a view as to whether it meets the Ladder-Marshall test? How can we, on your case, just look at look at the reports, especially where, as it seems to me, having looked particularly at Dr. Hussaini's response, it isn't just a question of pointing to the decisions, but involves the re-arguing to some extent of the underlying points and how the new Cassation decision and the other first instance decisions that are relied on fit with the Shell case and so on.
Yes, my lord, the Cassation case was at first instance, the Palestinian Cassation case. It is only 2 new first instance decisions that have emerged since then.
Oh, right.
So there is no new the Palestinian Cassation case, which was obviously a crucial part of the judge's findings, because it was a decision of the highest court in Palestine which came out 4 months before the first instance trial, and that's a crucial part of the judge's first instance reasoning. That's nothing to do with new evidence. The only new evidence is 2 new first instance judgments from the Palestinian courts.
Which is subject to appeal.
Which is subject to appeal. Now, as I say, we've not found an authority that really addresses, and I'm not, in a sense, for this submission, the only point I was making was there is much we could usefully do today if we got on with it, including that question, including whether 2 new first instance decisions assist this appeal court, and if they do, what you would do about it. As I say, nobody is applying to cross-examine, and as my lords will be aware, and I don't wish to misquote from memory, but certainly in the commercial court there are protocols about foreign law if the parties agree.
So can I just go back? I thought that Dr. Hussaini, at paragraph 8, relied on a Cassation ruling which was handed down on the 11th of September of last year.
Apologise, my lord. There is a Palestinian Cassation case that is certainly part of the first instance. Let me check the...
There is. That was the Shell case, I think.
Yes, my lord. It's a new case, Procter and Intercosmetic, which is has been through 3 levels in Palestine. That's the Cassation.
Paragraph 8 and following, which is at 12, I think. Sorry,
Yeah.
page 12 of the bundle of fresh evidence.
So, my lord, that's... I won't develop the substantive argument in a sense, because my submission is simply at this stage. There is much that could be dealt with in relation to ground 1.
But you do say, do you, that we are able just to look at those reports and look at the underlying translations of the decisions and form a view about that?
My lord, I cannot say that jurisdictionally you don't. You'll see in my primary case is that you look at the material before the court. That's my primary position, and that's what you do when you consider the judgment below. If it is right, and we've drawn them to the attention of the court, if it is right that the new material is relevant material, and as you say, both sides have different things to say about it, then yes, I certainly don't say that you cannot look at that material and form a view. That there's no jurisdiction that stops you doing that, and courts have done it, particularly when neither side is applying to recall the expert. And I accept, my lord, that in a sense, if I'm wrong in my primary point, then I'm wrong about it, and I'm arguing something slightly different on the secondary point, which is that the court can do that. But that happens. And so, my lord, yes.
Well, the parties couldn't apply to recall the expert.
Well,
because I mean, the first instance judge is functus. I mean, he's given his judgment.
Oh, sorry, I meant here. Either party could have written to the Court of Appeal and said...
It's not a question, that's a problem. That's the point. It's not a question of recalling the expert.
No.
It's a question of saying the court has to work on the assumption of the judgment given by the judge below,
Yes.
add it, and then add to it with new evidence.
Yes.
And then you get into the questions that my lord asked you.
Exactly.
So it's not really just a question of saying, as you would in front of a judge who'd heard the first instance
Yes.
expert
Yes.
evidence, you need to hear a bit more of it to put together with what you heard before. It would be a hybrid.
But the other problem is that under normal circumstances, and I appreciate these are not normal circumstances, if an appellant satisfies the Ladd and Marshall test, the court's normal response is to send the whole thing back for a retrial.
My lord, I mean, clearly, as you say, the circumstances in which that type of factual evidence arises are different to the matters that set out here. And in answer to my Lord Justice Popplewell's question, yes, we will be saying on this question, where you have the material before you, that would not be necessary to the extent that you consider, which would be the first question, the Ladder-Marshall threshold is satisfied in any event, either because of the nature of the appellate function, and are you really actually just looking at what the court... But is it really new evidence, the fact that the law has changed in Palestine in the sense that we understand that in the Ladder-Marshall? That's one question. And the second question, assuming it is it proportionate? And it would come down to that. I don't think it's a question of principle. You clearly could send it back for a retrial. But is it proportionate once the court has read the material and the expert reports to require this further cross-examination on the, and I accept, 3 new decisions relied upon it? Those are all matters that would require decision and submission. For the immediate purposes, whereas my lord has said the question is, what do we do? I simply say that certainly there is enough in ground 1 to occupy these legal teams and this court, were you to proceed to hear it today and tomorrow morning. And if it ended up that that's where you got to as a court, that we should send it back in that way, well, that would have been a result and a useful decision, because we'd know tomorrow, or when my lord gave judgment, rather than in 6 months' time. So, my lord, that's the possibility of hearing ground 1 today. I mean, if you're not with me on that at all, then I doubt, well, you're obviously not going to want to hear ground 1 and a bit of ground 2. So in a sense, I accept that that is a less attractive position. But again, in my submission, it's not impossible to have a situation where we set out the arguments as formulated in the skeleton arguments, which are effectively, as my Lord Justice Snowden has said, national law means it has to be a recognised nation state under the governing law of the contract. That's English law. Palestine isn't recognised under that. That's it. I mean, I summarise simply to sort of see that's the bit of the argument that one could have. I apprehend from what my learned friend said about not needing international law experts that he accepts the point my Lord made, that implied recognition for the purposes of is Palestine recognised isn't going to assist him for the reasons my Lord has already articulated.
Sorry, is part of your argument going to be that as a matter of interpretation, the parties couldn't have intended national law to mean Palestinian law because Palestinian law isn't recognised as a state?
Yes, or any other state.
Well, how can we get involved in that without HMG's input?
Well, it's obviously a matter for this court, but the parties have put expert evidence before the court, and it is common ground between the experts that His Majesty's government does not recognise Palestine. That is the common ground position. I mean, I can show you the citations if it would help. But the point, so, I mean, there's no doubt in the expert's view that if you ask His Majesty's government, as we're going to, is Palestine recognised as a state? The answer is no. What is said by my learned friend's expert is, well, that may be what they think they've done, but actually they have implicitly recognised under various canons of international law. And the point we take, which my Lord adverted to, is, well, that doesn't help as a matter of domestic law. So to the extent that whether Palestine is recognised as a state by His Majesty's government is relevant to the contractual construction issue, it is common ground it is not expressly recognised. There's an issue of implicit recognition, but we say we have a complete answer to that in domestic law. Now, I accept that doesn't mean I'm home on the contractual construction point, because I still need to persuade you that national law must mean the law of a nation state. It can't be given a different construction, as my learned friend would argue, but that's just contractual construction. So that is an issue that one could deal with at least provisionally today. And of course, I'm not suggesting, as my learned friend says, that whether His Majesty's government get to have their views taken into account is a fortuity as to when this court's judgment comes down. Of course, we would put in place a timetable, we would, it's up to the court, but give His Majesty's government time to make submissions whenever we hear ground to before any judgment is released. And then, as I have said, comments can be made by the parties in the light of those answers given by the government. That allows for the government's views to be fully taken into account whilst hearing as much of this appeal as possible.
But the government might say, well, in order to give you an answer on the question you formulated, at least the second one, we actually would like to hear the argument as to how it actually affects.
That is absolutely right, my lord. And, you know, my response to that, and it is a question of practicality, is obviously they can be provided with a transcript. Obviously they will see not just what the party's arguments are, but what my lord's questions are. And in many cases, I don't want to overstate it, but it is certainly not necessarily more inconvenient to intervene having actually seen how the debate has gone and what the real issues are as crystallised, and then to intervene and say, actually, these are the points, than it is to intervene at this stage where effectively they would be trying to see what they might make of the issue. So it doesn't, in my submission, preclude an effective intervention if they have to rely on transcripts, which I'm sure can be obtained by the court. They normally are. And
well, hang on. Have you arranged for transcription of this hearing?
I don't think it is being transcribed, but as I understand it, recordings can be obtained, and that's how it's always worked.
I think it's being live streamed.
It's being live streamed.
Probably means that you can get the result publicly.
Somebody with court's permission could watch the YouTube and transcribe it. Yes, if we had to, and certainly they stay around. I don't want the court to think I just sit there watching my own stuff, but I know they do stay around for quite a long time after the hearings. So, my lord, that is what we could do with issue 2, although, as I say, I accept entirely that really my primary case is if we're going to get on with something, issue 1, we have plenty to get on with in issue 1, it may even take up most of the time. So then the other option...
And part of your preferred option, have I understood, is not to ask the government the questions yet, but to deal with what you suggest we should deal with.
Yes,
for the court to make a decision on that.
Yes.
And if at that stage it regards what you're calling round 2 as arising, then to ask the questions, including whether the government would like to intervene, which it would then have to do by having the transcripts rather than being here to hear the argument.
Precisely. And my lord, I'm not suggesting we don't tell His Majesty's government what is being proposed, given the court's direction and everybody's agreement. So we can tell them that's what's going to happen, and that there may be an issue arising down the line, but it's not an issue that arises at the moment. That would be.
And if they wanted to say, well, actually, we'd rather be here and hear the whole of the argument, it would be too late.
It would be too late on ground. Yes, it would be too late on an issue which nobody is suggesting they have any legitimate interest in, and that is not a criticism. But nobody is suggesting. Sorry, I accept my
say to the extent that it may inform their response on to the second question, on questions of policy, because they are going to need to have an understanding of the context in which the policy question arises. I mean, to put it crudely, they might take the view that there isn't a policy one way or the other on private rights being contractual rights. It all depends on the particular contractual rights and the particular territory concerned.
And I think it's
and a combination between of the two.
No, I accept that, but I think my response is the same as really I gave to my Lord Justice Snowden. Yes, in a sense, if we go ahead, of course, you are depriving them of the opportunity of saying, please don't go ahead for that reason. I accept that on ground 1. But in my respectful submission, the court can and should take into account the fact that nobody is suggesting the interest arises in relation to ground 1, and there will be transcript, however obtained, which will enable them, and potentially a judgment of this court. I mean, that could be determined, but assuming that we wait until a ground 1 judgment is handed out, they would then not only have the ability to see the argument and the context, but actually what the court was proposing to say about this particular Palestinian law. And the very, clearly His Majesty's government's job will be far easier if it's actually looking at what it is that the Court of Appeal might be minded to say about Palestinian law, subject to arguments of public policy. So, I mean, yes, to that extent, and I said, I accept if we go ahead, we will be depriving that opportunity of His Majesty's government saying, no, don't do anything. But I'm seeking, or at least making the submission, that that is not a realistic scenario and wouldn't be a reasonable request in all the circumstances they've made, because we are not touching on those points on which His Majesty's government's interests are obtained.
I'm sorry, I'm a little bit lost. You keep referring to ground 1.
Yes, I apologise.
Ground 1 of the appeal, at any rate, is that the court paid insufficient regard to the fact that the appellant had been registered by the commercial agents directorate.
I apologise. That's
So what are you actually, when you say ground one, are you talking about the question whether national in the contract means Palestine?
no. I
Is that ground
apologise,
one?
my lord. When I say ground one, I mean effectively the appeal as originally submitted. Before Lord Justice Males made his order,
Oh, I see.
we had a ground, and I have called that, I think I've called it in the skeleton, I've called that ground one effectively as the original appeal.
Right.
So it's everything that existed before this point arose.
I see.
And that's what I'm saying as my primary submission we can get on and determine.
And that, as I understand it, assumes that this court, if need be, can apply, quote, Palestinian law.
Yes, I mean, as I have submitted within the context of the fact that no relief is sought
Yeah.
if we succeed, so you'd simply be saying appeal dismissed,
Yeah.
and in my submission, if you are otherwise in my learned friend's favour, you would not need to give effect to anything or declare anything, merely order that we go on to here ground two, which I apologise, but I'll keep calling ground two now. We've got that. So ground two are all issues Lord Justice Males' point has given rise to,
I follow.
which includes both the contractual construction point and the public policy point. And I apprehend entirely they are, in some ways, separate questions.
The
Because
construction point is a respondent's notice point.
precisely, yeah,
One might divide them into three, as it were.
precisely,
There's the
exactly,
construction point, which is the respondent's notice.
precisely.
And then there is the new question raised.
Public
by
policy,
Justice.
exactly, my lord. So, I mean, that's a sort of why we, and in my submissions, no question of cost being wasted. This cried out for a directions hearing this morning, whatever this court said. But that's why we are minded to invite the court to continue, at least with the pre-existing, my Lord Justice Males grounds of appeals. If that doesn't, if that course doesn't commit itself
The
to the
saving of costs would have been a great deal more, or you would be at less risk of, as you say, wasting costs if the parties had asked HMG their view in light of Lord Justice Males' order granting permission to appeal.
My lord, I accept that. Now, without, I mean, with due deference, and this goes for both parties, we didn't do that. The parties did adduce expert evidence, which we hoped would be of assistance on both sides from that. And I made the submission with all due deference. Obviously, my Lord Justice Males' order was that the issue be addressed in skeleton arguments, not that anything else be reached. I entirely accept, particularly in the light of the public policy arguments, and the parties have agreed with that. But given where we are in my submission, clearly directions hearing is appropriate today. We need to decide, and it would be far worse if we all went off without a clear steer as to what should happen and what we can do.
Yeah.
If I just complete, if we are to adjourn today, my learned friend and I very much hope there will not be controversy about the way forward in the light of the steer given by this court. Clearly there should be context given to His Majesty's government. They probably don't want to be wading through some of the stuff about whether the cars were clean or dirty or not, which does not arise on this appeal. There are issues which do engage Palestinian law, and they can be directed to those. We were minded from our side, contrary to my learned friend, not to submit too much at the first time. They've got the skeletons which summarise what the experts are saying, and effectively to do what my lord had done, the judgments, the order of Lord Justice Males, the notice of appeal perhaps, and the skeleton arguments, to encourage, and again this will be subject to my lord's directions, to encourage His Majesty's government to decide if they wish to apply to, it depends on which way you go of the three options, but to encourage, assume we adjourn completely, to encourage them to decide whether to apply to intervene within a reasonable period, which could be debated, and to encourage them to answer the questions if they are so minded.
Yes, I noticed in looking at the authorities you've given us that in the family cases, the government did intervene either in submission or evidence or both, setting out HMG's stance on whether the law of the particular, let's call it territory, could be applied, or whether there were policy objections to it.
Yes. No, and that's yes. So I mean, let's assume that you decide to adjourn today, then the Majesty's government can be invited to do that, and within hopefully a sensible deadline. And none of my submissions are on the basis that it is unlikely His Majesty's Government will take any interest in that. I've very carefully not made that submission. I've tried to identify things we could do without impinging on His Majesty's Government's interest, but I entirely accept that there are issues which impinge on them. And as my learned friend says, and it's entirely up to the court to proceed, if we increase the time estimate to 2 days, which would effectively give half a day for His Majesty's Government if they chose to intervene, then there's obviously a risk the hearing is then shorter than it needed to be, but it does mean we don't need to relist again if there is an intervention. That may be a way of trying to militate against excessive delay, recognising that some will be inevitable.
Yeah. Can I raise one further matter, which is the extent to which it's going to be for this court to grapple with, or whether there should be a remission for it to be dealt with at first instance. Normally, of course, this court takes the view that any substantive issue should be ruled on by the court of first instance before an appeal is heard, partly because that doesn't reduce the levels of a number of appeals, and partly because it wants to have the benefit of it. Now, we're in slightly unusual circumstances, and I'm not myself suggesting that at the moment we should be ordering any remission, but just looking forward, assume we now adjourn, contrary to your primary position, there will then be a response from His Majesty's Government. We may anticipate that it's tolerably clear on the first question. It may be more or less clear on the second question. And it may be, I'm speculating, that the terms in which that answer is given would itself give rise to questions as to whether there ought to be a first instance decision first. That may be compounded by the view the parties take as to what scope, if any, the answer to that question leaves for what I would regard as replacement expert evidence on the international law plane, and that would itself give rise to a question as to whether that's evidence we would need to hear orally tested, and whether that's something that should happen in this court or the court below. And what should happen in relation to the fresh evidence on Palestinian law might itself be infected by those questions. So would it be appropriate to, if we go down this route, contrary to your primary submission of adjourning now, to leave open for the parties' subsequent submissions in writing perhaps, where we go next, including the question of remission and expert evidence, until after we've got the answer to those questions, and for the court then to give directions at that stage.
My Lord, I absolutely see the force in what my Lord is saying, and I cannot at this stage rule out the possibility that His Majesty's Government's responses will give rise to these sort of issues and extra debate. It could be me asking for extra evidence to come in, or saying that can't be what His Majesty... I mean, I can see we can't rule out a number of possible possibilities. However, so the question, and I don't, in my submission, gives rise to 2 points. The first is the fact there are so many unknowns about ground 2, including, of course, the fact you don't have a first instance decision on these issues, is perhaps one factor militating in favour of getting on with ground 1, given it is a possibility of disposing of the appeal without going down that route. And secondly, and again, I can only make this as a submission, I appreciate the court practicalities are a matter for this court, one could list a 2-day appeal, recognising the possibility that it would be adjourned to remit to first instance in certain circumstances. I'd appreciate that's not ideal, it's not hazardous, but it's not necessarily the most likely circumstances, as my Lord recognises. I mean, His Majesty's Government could say, no, we do what we want. A commercial case, we don't care. But it might not. But it would be possible, recognising the risk of adjourning for remission, to list it on the basis it will go ahead. And as my Lord says, then there could be written submissions about, well, actually, now His Majesty's Government has said how important this is, how much the policy is hinged upon it. This the parties might agree it needs to be remitted, or the court might decide it needs to be remitted. But
So is the subtext you're concerned about being able to relist it now, so as to get a date?
my lord, yes, I know it's
reasonably promptly, even though we don't quite know when we're going to get
my lord,
the
yes.
government response.
My lord, yes. And I mean, and there are good practical reasons. Obviously, this is quite a long-running case, and it's obviously perfectly entitled for any party to say we should get on with it insofar as it is possible. These are not normal circumstances, and I recognise the particular circumstances must be given great weight. But yes, what is obviously unfortunate is if we adjourn, we find that actually His Majesty's government does not consider this touches a matter of policy. They say we don't recognise HMG, as both the experts have confirmed. We're then in a position of effectively going back to the start, and if we haven't even relisted it, then we could be. I think it's normally a year to get a list.
I think it's less than that these days.
So
But I mean, the blunt truth is surely that delay hurts the appellant rather more than it hurts the respondent.
there is.
I mean, you are potentially at risk of having to put your hand in your pocket and pay Kima compensation under the Palestinian Law 2 of 2000. And for as long as you don't have to put your hand in your pocket, in a sense, you're better off. So, I mean, if the appellant is willing to accept the delay, which I would have thought prejudices them rather more than it does you, why are you not?
I mean, I think 2 points. Firstly, I'm below Fred could speak for himself, but I don't think he's against the submission that we get it listed for that reason. And secondly, and it's not to, I haven't taken detailed instructions and won't make submissions on the corporate client, but certainty is valuable in a commercial business.
I appreciate that. Both
and
valuable.
It is yes, they're at risk of having to put their hand in their. I mean, in a sense, this is a claim for a declaration, so they're not going to put their hand in their pocket in this set of proceedings, come what may. But it may. Who knows what the appellant has in mind? But it's not an existential amount of money, and so they'd like to stop. They'd like to stop paying legal fees, I think, and delay does rather duplicate and increase those. So there are commercial reasons to get on with it, even recognising that as I stand here today, I have everything I could possibly have wanted to achieve from these proceedings, and it's only if that changes that it will be a matter. But that is the submission I'm instructed to make. As I say, I'm not sure whether everyone particularly opposes it. Relisting has advantages in that sense, and I accept entirely the importance of the court's reluctance to list something that might then adjourn. But it doesn't. That's my submission on that. So, my lord, unless I can assist you further on the way forward, those are my submissions. I just look behind me for 1 second.
Thank you very much. Mr. Sinclair, do you wish to reply?
I was only just going to say on the point that Ms. George just dealt with. I think I don't feel strongly about it. It's a matter of practicality, but I think it would be sensible for us to hear back from the government as to what they intend to do before we relist, because we won't know. Yeah. And it may raise the point my lord made about something more complicated than just relisting. So that would be my preference. But obviously, as has been recognised, we do want to get on with things as the appellant, but we also want to do it in an orderly way. So, and really the prejudice is on us from delay, and I am the one who is suggesting it. So I think your lordships can take that into account. The other thing is, my lord Popplewell made the point about jurisdiction at one point. And our case, obviously, is that Her Majesty's government is not going to be offended by applying Palestinian law. But one could see that they might be. And I suppose it's possible that their response is so vigorous on this issue that, in fact, it would not be appropriate for your lordships to even, on a contingent basis, be making determinations as to Palestinian law. I don't. It's our case, they're not going to do that, but I suppose there is a universe in which that might happen. So that would suggest an argument in favour of adjourning the whole thing. That's all I had to say. Thank you.
Right. Well, thank you. We'll just go outside for a minute and see where we go from here. Don't leave the courtroom. We'll be back shortly.
Right.
not be seen. Maybe. Just because we say that's quite common as well. No, interesting. He was in court yesterday on a different case. They're very impressive. Yeah. What? Yeah. Oh, yeah. They're all. I think they're all, aren't they? Are they not? But they're interested in issue. They'll probably try and keep the case themselves. That's interesting. Yeah, obviously. Popplewell. I think they were the got it. What's your prediction?
Careful what you wish for. Careful what you ask for.
That's true.
ayes if able.
I'm going to give a short judgment, and I would ask that a note or transcript of this judgment be supplied to His Majesty's Government when the questions are being asked. The ultimate issue on this appeal is whether Kerish International Motors Agency is entitled to compensation under the Palestinian Commercial Agents Law number 2 of 2000. In a judgment given on the 7th of May 2024, Mr. David Quest KC decided that they were not, but in giving permission to appeal, Lord Justice Males said this in paragraph 3 of his order, quote, "However, a prior point arises which will need to be addressed even though it has not been raised so far. The case has proceeded on the basis that national law in Article 19.1 of the DSSA refers to Palestinian law. However, as I understand it, HMG does not recognise the state of Palestine. It will therefore need to be considered whether the commercial agents law can or should be recognised as national law for the purposes of Article 19. The issue should be addressed in skeleton arguments," unquote. What Lord Justice Males was plainly referring to is what is generally referred to as the one voice principle. It is well established in English law and was extensively considered by the Supreme Court in Deutsche Bank London branch and receivers appointed by the court, 2021 UKSC 57, 2023 Appeal Cases 156. In a nutshell, the principle means that the court may not come to a decision that contradicts the policy of the executive in matters relating to foreign affairs. The following relevant propositions emerge from that decision. First, the recognition of foreign states, governments and heads of state is entrusted to the royal prerogative. In this area, the judiciary defer to the executive, Deutsche Bank at paragraphs 64 and 69. If there's any doubt about the position of HMG, the proper course is to seek information from the Foreign Commonwealth and Development Office, see Deutsche Bank Act 76, citing Duff and Calantan. What matters is the attitude of the executive, of which the executive statement can be the only authoritative source, and which should be treated as conclusive, Deutsche Bank at paragraph 78. Although implied recognition is a principle of international law, it is inappropriate for courts to rely on notions of implied recognition. There is no scope for the application of implied recognition in domestic courts. See Deutsche Bank at paragraphs 96 and 98. In addition, the cases establish that in principle the acts of the government of an unrecognised state cannot be recognised by an English court. But there is an exception to this principle where the matters in issue relate to private and family rights. See MM and NA, 2020 EWHC 93 FAM, 2021 FLR 967. But that exception is qualified by the requirement that recognition must not conflict with public policy. Public policy in this context means the stance of HMG. In the cases with which we have been supplied, HMG has either intervened or at least put in evidence explaining to the court what its policy was. It was for that reason that the court considered that it might not be open to this court to decide whether to give effect to Palestinian Commercial Agents Law number 2 of 2000 without being informed of HMG's policy and or diplomatic stance. It was for those reasons that in advance of the hearing, this court conveyed the message to the parties that it provisionally considered that the parties should approach HMG jointly with the following questions, quote, "At the request of the Court of Appeal, we seek answers to the following questions. 1. Does HM government recognise Palestine as a state? 2. If the answer to that question is no, would it be contrary to the policy of HM government for the English courts to give effect in the context of a contractual dispute to Palestinian laws applied by courts in Palestine and applicable to commercial dealings between the parties, unquote. The parties were also directed to inquire whether the government wished formally to intervene in the proceedings. Further discussion amongst this constitution has resulted in a request to the parties to include, in addition to those questions, the judgment at first instance, the appellant's notice and the skeleton arguments in this appeal, and as I said at the outset, this short judgment. We have convened this hearing to decide how best to proceed in the light of what has happened. There are, in essence, three options. First, to adjourn the appeal, pending a response from HMG. Secondly, to go ahead today and tomorrow and hear the appeal argued. And thirdly, to argue some, but not all, of the substantive grounds. Of the three options, we do not consider that it would be sensible to chop up this appeal into its component grounds. If we were to hear argument on the question whether national law in the contract means Palestinian law, and or whether under Palestinian law the appellants are entitled to compensation, we would in effect be required to trespass into an area which is the prerogative of the executive. The issues would be, as in the nature of preliminary issues, but in their logical order, they are, firstly, does national law mean Palestinian law as a question of construction? Secondly, if so, can Palestinian law be applied? And that is a question for the executive. And thirdly, if so, are the appellants entitled to compensation under Law 2 of 2000? Of the three options, we consider that the only really viable option is to adjourn this appeal. We are, of course, conscious that this will entail delay and possibly additional cost for the parties, but we consider that we can accommodate the parties by directing that there should be a provisional listing with a time limit of 2 days, not before the 1st of December 2025, so as to give the government time in which to respond to the questions and, if so minded, to apply to adduce evidence and or make submissions. It would be desirable that the resumed hearing be before this constitution of the court, but not essential. However, we do reserve to this constitution of the court any interim directions which may be needed as a result of the response of Her Majesty's government, and we direct that the parties keep the Civil Appeals Office up to date with any further developments.
I agree.
I agree.
Thank you, my lord. Lords. What do we need? I think we know what we need to do. I'm just wondering if we need any guidance on next steps.
Well, as I've said, the Deutsche Bank is at the moment. It seems to me to be clear that there's no room for implied recognition.
Yes.
Whether the parties want to consider that in the light of what the experts say, they may want to wait until HMG's response before meeting, but they certainly should meet at some point before any resumed hearing. And I think the same is true of the Palestinian law experts in the light of the new material, which may or may not be admitted at the resumed hearing of this appeal.
Okay.
My lord, I'm sure that can be that could be the subject of discussion between the parties to ensure that, and I can see it may be awaiting a response from HMG before crystallising those discussions is sensible and efficient. And it may be my learned friend will tell us more about Palestinian appeals, and again, if they're going to come down the line, it may be sensible. But I'm sure the parties can agree on that, and I think we know to get the
Appeal?
Yeah. my lord.
Very well. We're minded to say cost in the appeal.
Yes.
Persuade us otherwise?
No.
No, my lord.
And should we draw up an order?
Yes, please.
But not reflecting the point about the experts meeting. That's something that we've heard, I think. Or are you directing?
I don't think that needs to be directed at this stage, not formally at any rate, but you will keep it in mind. And if we have to give interim directions following HMG's response, we may then, at that stage, direct her.
My lord, yes. So
Thank you.
clearly, if something happens
Yes.
that gives rise to profound disagreement, we're very grateful this court has indicated it would make interim directions. In that, we'll obviously do everything we can to avoid that situation.
Well,
but-
I think the court will probably want to make
yes.
directions, knowing what the parties' views are
Yes.
on the areas we've touched on, including remission.
I think Lord
Well,
Justice
I,
knows
simply, do the parties know to whom at the FCDO to send this request? Are you confident that you have the right person?
I think they sent an email to the wrong person.
We do. I've apologised to my letter friend. I've apologised to the court. But,
we were going to research who the right person is.
Well,
if your lordship knows, then that would help.
I do have a suggestion, and my clerk will supply you with the name of, I think, the head of the legal department at the Foreign Office, Foreign and Commonwealth Development Office, who may at least be the initial, suitable initial point of contact.
that would be very helpful. Obviously, the quicker it gets to the right person who's going to be charged with handling it, the better.
Thank you.
Right. Thank you very much.
Very grateful, my lords.
All rise in favour.